Hey everyone. So while we've been really busy with the election, which I'm going to do another podcast about after and exactly how I feel, and hopefully the next steps for Pierre Polyev, but we've totally missed out. I mean, the Justice Center for Constitutional Freedoms actually won in court just on April 17th. Okay, and this one is a good one for us. All right, the Justice Center for Constitutional Freedoms is pleased to announce that the Nova Scotia Supreme Court has dismissed a discrimination complaint on the basis that there is no right not to be offended. In her decision, Justice Denise Boudreau ruled that being upset or offended is not the same as discrimination. So here in Canada, as you know, we have a lot of stuff on our social media banned. Um, you know, where I know that Carney might be releasing again the Online Harm Act. But for now, it's good to know that even if he tries to do that, the courts aren't seeing it. Now, this outcome is a significant victory that upholds the right of Canadians to express controversial views in public without having to fear being charged with discrimination. We've been seeing it everywhere, guys, where you can't even be out preaching now, your religion. You know what I mean? Like in Canada, we can't. Um, it's not as bad as the UK, but I mean, we're getting there. Now, in 2019, a student accused St. Mary's University and the Society for Academic Freedom and Scholarship Society of discrimination after Professor John McKinnon had published an article critiquing the state of academic integrity in post secondary institutions. In this article, Professor McKinnon asked readers how many academic regulations have been relaxed or ignored, how many transcripts have been tampered with, how many grades inflated, and the student only referred to as Q in this publication, soon realized she was its subject. 13 months later, she filed a discrimination complaint against the university and the Society of the Nova Scotia Human Rights Commission. The commission conducted an initial investigation. So on June 6, 2024, the commission referred the complaint to the Board of Inquiry for a formal hearing to determine whether discrimination has occurred under Nova Scotia's Human Rights Act. To be referred to a Board of Inquiry, the commissions must be satisfied that the allegations, if proven, could establish a case of discrimination. On July 30th, 2024, the university asked the Supreme Court of Nova Scotia to review the Commission's decision to escalate the case by referring it to the Board of Inquiry. And in January and February 2025, lawyers for the university and the society argued in court before Justice Denise Boudreau that the complaint should never have been referred to the Board of Inquiry. In addition to pointing out prudential unfairness due to unreasonable delays, the Society argued that there is no evidence of discrimination and that human rights laws do not exist to prevent hurt feelings, humiliation, or offensiveness. Now, on the contrary, discrimination laws are meant to address only the most extreme type of expression that has the potential to incite or inspire discriminatory treatment against protected groups on a basis of a prohibited ground. And the original article, the Society argued, posed questions on issues of public importance, the integrity of academic institutions. Now, to decide that such inquiry is discriminatory would be a violation of freedom of expression, protected by Section 2B of the Canadian Charter of Rights and Freedoms. So, on April 17th, Justice Denise Boudreau of the Supreme Court of Nova Scotia dismissed the discrimination complaint. In her decision, Justice Boudreau wrote, "Being upset or offended is not the same as discrimination." She also confirmed that there was no evidence of any burden, obligation, or disadvantage imposed upon her, the student, not imposed upon others. At paragraph 74 of her decision, Justice Boudreau even saw fit to note Let us recall the freedom of expression is a charter protected right in Canada. So again, she even saw fit to note, let us recall that freedom of expression is a charter protected right in Canada. So, constitutional lawyer Chris Fleury remarked, my client and I are elated with the decision. The court rightly agreed with our submission that freedom of expression is not to be interfered with, even in the context of a human rights complaint. There is a significant victory for Canadians overall, and particularly for those who seek to express controversial opinions, he explained. So, though we have a lot going on right now, things could get worse, guys. And knowing that the Justice Center of Constitutional Freedoms are there every step of the way and they are winning and gaining ground. So, everything we might think we're going to be losing, let's just be happy that they have our backs.